Chief Justice and Justices of the Supreme Court of the State of Michigan. All persons having business with this honorable court are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States, the State of Michigan, and this honorable court.
Good morning. It's truly a great honor for our court to be in Petoskey this morning to hear the first ever argument after 182 years in northern Michigan. We have never pondered a legal dispute while overlooking Little Traverse Bay ever before, and we're honored to do so today. I'd like to very briefly introduce my colleagues. They are Justice Brian Mazzara, Justice Bridget McCormick, Justice David O'Brien, Justice Richard Bernstein, and Justice Jim Wilson. Our court typically deals with 2,000 cases per year, and we're going to be doing our best to bring the same standards of legal analysis and judgment as we do in our Lansing Hall of Justice headquarters. Because of a recent retirement from our court, we're down one justice, but we are expecting an appointment from the governor in the near future. At that time, our new colleague can determine whether he or she will participate also in this case by reviewing the transcript and the video that are being made this morning. If he or she does decide to participate in this case, there may be 7 justices who will be participating in the resolution of today's case. Before I call today's case, I'd like to take a few moments to thank our hosts and to welcome area students and educators. Thank you to the Petoskey School System, the Emmett Charlevoix County Bar Association, the Petoskey Educational Foundation, community businesses, including especially the Perry Hotel, the Emmett Police Department, the County Sheriff's Department, and the Michigan State Police, the latter for their typically professional support. Thank you also to the mentors in this program, Judge James Earhart and Christina DeMore, who both prepared students for today's arguments. We'd also like to thank our attorneys today, Ryan Day and Camilla Barkovic, who argued the case and have consented to share their perspectives with students afterwards. Let me also thank Lisa Smith, the Rhinebeck District Court Administrator in particular. Students in the courtroom today represent the high schools in Robinson, Beaver Island, Boyne City, Boyne Falls, Central Lake, Charlevoix, Concord, Boyne, East Haven, Harbor Light, Paston, Petoskey, and St. Michael's Academy. We welcome you and we welcome everyone watching the live stream on Petoskey's YouTube channel. Without these and other local partners, the Supreme Court could not have a successful Court Community Connections program. This is the 20th such program that we've had, one designed to introduce the students of our state, in this instance the students of Northwest Michigan, to the appellate judicial process. As is the case with all of our community correction events, our court is dependent upon the local bench and bar and the local educational community for their support and cooperation. Our hosts have always responded with great enthusiasm and support, and Petoskey has done a wonderfully outstanding job in assisting this court in extending to us their hospitality, and we thank them all. 2 housekeeping items, please. With the exception of the media and professional photographers, please do not take photographs once the oral argument has begun. There'll be opportunities for that during the reception afterwards. Also, if you have not done so, please turn off your cell phones for the remainder of the proceedings, if you'd be good enough to do so. Also, following oral arguments, students and others may remain in the courtroom for the debriefing with the counsels for the parties. Tom Clement, our Supreme Court General Counsel, will moderate at that point. We'll then have a reception afterwards from approximately 11 o'clock to noon. Oral argument in this court is a critical and generally the final stage in the Michigan judicial process. It offers one last opportunity for the losing party in the Court of Appeals to persuade the courts that a different result is required under the law. It is also the part of the judicial process at which this court attempts to make as clear as possible what the requirements of the law of our state are, so that courts in Emmett and Charlottesville and Petoskey will have the same understanding of the law as courts in Grand Rapids or Flint or Detroit. By now, the justices are familiar with the case before us. We've studied its facts and its legal aspects closely. The questions that we'll be asking during our argument and counsel's answers will help us reach a final decision, and equally importantly, they can assist us if we eventually issue an opinion to craft the best opinion that we can so that Michigan law can be as clearly understood as possible. Finally, let me leave you with what I believe is the single most important thing that students need to know, and that is we're not today judging the merits of the law that are before us. We are simply attempting to determine what that law means, and that, of course, is a part of our constitutional separation of powers, where it's the responsibility of the courts to give meaning and to interpret our laws, but it's the obligation of the legislative branch of government to establish and to make those laws. So let us now proceed. There will be 15 minutes for each side. There will be a 2-minute free fire zone at the beginning of the arguments, during which we will not ask questions unless that period is waived by the counsel. The case is People v. Raleigh. The appellant, the party that is lost in the Court of Appeals, and which is seeking to alter that result, will begin, and then the appellee will proceed after that. So could we please ask the appellant to step forth?
May it please the Court, Marilyn Day, Assistant Prosecuting Attorney, representing the people of the state of Michigan in the Oakland County Prosecutor's Office. I'd like to reserve 2 minutes of my time for rebuttal. In the state, it is unlawful for a person to operate a vehicle while intoxicated upon a highway or other place open to the general public or generally accessible to motor vehicles, including an area designated for the parking of vehicles. The question for this court to decide is whether the location where the defendant was operating his vehicle, his driveway, was generally accessible to motor vehicles. In essence, the Michigan legislature has already answered this question based on the definition of private driveway under the Motor Vehicle Code. The Motor Vehicle Code defines a private driveway as any piece of privately owned and maintained property used for vehicular traffic, but is not open or normally used by the public. If the legislature has already defined a private driveway as being used for vehicular traffic, it by necessity is generally accessible to motor vehicles. And it does not matter whether that particular area is also open or normally used by the public, because in 1992, the reach of the operating while intoxicated statute was amended to include the language generally accessible to motor vehicles. And an area that's generally accessible to motor vehicles need not also be open to the public, because the two phrases are disjunctive phrases based on the use of the conjunction or. Therefore, this case should be easy for this court to resolve, because the legislature has identified a piece of property, a private driveway, as being open for vehicular traffic, and the legislature does not require that it also be open or normally used by the public. The plain language of the statute also is consistent with this analysis. If you look at the word generally, the dictionary definition means usually, ordinarily, or for the most part. Accessible means able to be reached, accessed, or used. A private residential driveway is usually, ordinarily, or for the most part, able to be used or reached by a motor vehicle. It is not the unrestricted number of potential users.
I just have to ask a question.
And first off, thank you for being here. And I guess the question I just want to start with is, help me to understand, and I've been pondering this case, and I'm just trying to gather, how is this not an example of governmental overreach?
It is, the legislature has the discretion to regulate public policy. This is just under the operating while intoxicated statute. Under the DNR code, under the Environmental Protection Act, if you're driving a snowmobile anywhere in the state, you can be criminally liable. It's a police action, the public policy, and the legislative policy in order to
So let me do a quick hypothetical, and this is kind of what, and I want you to kind of help me through this. So this is my hypothetical. Let's say you have college students and they're graduating and they're having kind of a graduation party, right? And they're on a large property, very large property, and they're down at the lake and they're having a great time, and they have their car and they have the keys in the ignition of the car because they want to listen to music. And the car then is on because the keys are in the ignition, and they're listening to music, and they're using the car as a radio to kind of enjoy the music of the day. Under that situation, since the keys are in the ignition, they're on private property, they're far away from a public road, could they then be held liable?
Well, that is not the issue before this court, but I will answer it to the best of my ability. First, the issue is whether the person was actually operating the vehicle. And
right, I know.
And there has no case law that says the mere fact that your keys in the ignition means you're operating the vehicle. So that's one hurdle that you would have to overcome.
Right, let's just change hypothetical for a second. Let's just say then they move the car, a short distance, but it's on private property to get it closer to the lake.
I think if the property was being used at that moment for vehicular traffic, then potentially, yes, you could charge someone in that particular situation. Because if you look at the word generally accessible to motor vehicle, generally it's not a limitation. It's actually an expansion of the word accessible. Any area basically that's accessible to motor vehicles would fall within the statute. But I want to get back to this particular situation because we are dealing with a driveway, which by the meaning of the word, it's used for vehicular traffic. And if we look at driveways in other areas that are meant to be used for vehicular traffic, it is clear that the plain language of the statute applies. As I was indicating,
to Justice Bernstein, I think maybe what you said is a little broader than what I expected you to say. So it sounded to me like what you said is if it's accessible to motor vehicles at all. So in Justice Bernstein's hypothetical, there's a grassy area, it's not on a road, they've driven off the road through the grass down to some lake, and the mere fact that a motor vehicle can access the place is sufficient, then if that's right, then what is generally doing?
Well, generally is an expansion. Like in our particular case, there is some, it hasn't been fully identified in the facts, but there is some evidence that the police car might have been blocking defendant's driveway. At that particular moment, his driveway might not have been accessible to motor vehicles, but it's generally accessible to motor vehicles. And I think generally can be used broadly, like a community that has a gate. Okay. I'm sorry?
Would you please speak into the microphone?
Yes, like a community that has a gate. All right, once you get inside the gate, that area is generally accessible to motor vehicles, but there are restrictions on how you can get into that area. It is generally accessible to motor vehicles at that particular point.
So under your definition, you would have us read the statute to say you can be liable, by definition, anywhere that you could have been found to be drunk driving is a place that falls within the statute. So the statute covers the universe of places that a car could potentially go? There's no restriction in the statute?
I don't want to have this court reach that point, because I know it would be problematic to get the necessary votes, particularly for that particular argument. What I want to focus on is when we're dealing with an area that we know is used for vehicular traffic, which it would be inside of a gated community or a paved driveway. Any place that we know is accessible to motor vehicles clearly falls within the plain language of the statute. And this is a MOA, so we're talking about, and a question to be asked is whether the private driveway is generally accessible to motor vehicles. It is, because it does not matter that there were restrictions, or the fact that people are restricted from a particular area is not what is meant by the word generally accessible to motor vehicles.
That's exactly what we're trying to figure out, right? I mean, if it were that easy, you guys probably wouldn't be here. We probably could have just figured it out and written something. But so what work generally does is the question. I think that's the question for everybody. And I looked at that snowmobile statute too. I got interested in snowmobiles, boating,
ATVs, yeah.
off-road vehicles, and they all have a much easier statute. I found myself thinking, why didn't the legislature make it easy here? If you just said, don't do it, anytime you're drunk and you're on a snowmobile, you're guilty, that's really easy. But here, they didn't do that, so we have to try and give meaning to all the pieces of the statute. And the first two clauses seem to be relevant to driving anywhere that's public.
Correct.
And then this one is supposed to give meaning to driving places that are not public. You can't drive any private place drunk and get away with it. But what work generally does is the question. You keep saying it expands accessible, and I'm not quite following that, because to me, if it's accessible at all, then my yard's accessible, then you could drive anywhere. But generally feels to me like it should contain it a little bit.
Well, in this period, and it's not, it doesn't depend on who is actually driving.
So the definition of generally is not dependent on who has access, got you there, but how does it expand accessible instead of
the only way it expands accessible is when we're talking about an area that's currently not accessible, okay? Like I said, like the driveway that has a temporary obstruction.
Security.
Yes, that is how you expand it in that particular meaning. You can expand it in that particular meaning. But I do agree, and I don't want to get into every place in the state of Michigan is open to is generally accessible in motor vehicles, because as everybody recognizes, the legislature would have potentially have said, within the state, like they did for the commercial vehicle.
Write an opinion that is going to address these situations. And so I just want you to know, last night I had dinner with some students from out there, from St. Michael's Academy and Petoskey High School and Charlevoix High School, and they inspired a question. And it's along lines with what everyone else is asking. As it relates to private property, where exactly would you have us draw the line for generally accessible to motor vehicle? Where would it end? So you have, let me finish. They described it, as they're talking about this, there's a driveway, a cement driveway, and then the cement driveway ends, and then there's a dirt road, and the dirt road goes on for several hundred yards, and then there's a garage all the way at the end. Does it end at the cement portion? Does it take you to the dirt road? Or even if the dirt road stopped and then there was nothing but grass and there was still a garage another 100 yards beyond, would that whole area be covered under this statute? I
believe it would, because that whole area is generally accessible to motor vehicles, because you can operate your vehicle in that particular area. If there's sure signs of use of that motor vehicle being traveled on that particular area, then it's generally accessible to motor vehicles. But a driveway in and of itself is a different story. And the issue we do want some bright lines, because like the police officer here, what was the police officer supposed to do? The argument by defendant is, okay, so he was too far back in his driveway, so that's not generally accessible. Well, how is the police officer going to know what area specifically is generally accessible, especially in this case when the driveway is relatively short, approximately 75 feet, and he came a third of the way down, and he got down.
Help me but this is what I'm trying to gather, and I think, I'm just trying to follow up on the other justice's question, which is, what would not be accessible? Generally accessible. Can you give me an example of a situation where
He wants to know where he can go drive drunk.
Yeah, pretty much. And I'm blind, so it only makes it even better. He can rack up the offenses. So what would not be accessible?
Under this particular statute, because there's a whole different issue if you have an ATV, because even if you have a Jeep, nowhere in the state of Michigan can you drive off-road.
No, a nice sedan. Where can he drive his nice sedan drunk and get away with it? What's the answer to that question?
Well, I mean, I think the statute is very, very broad. Basically, if it's usually, ordinarily, or the most part, accessible to motor vehicles. I think the rule that we should apply here is if the area it's meant or designed for vehicular traffic, then it clearly falls within the statute, if it's meant or designed. Or even if it's temporarily being used for vehicular traffic. If you're having a big party in the backyard and you're intending or you're meaning for that area to be used for vehicular traffic, the speedway in the Nickerson case, that might not always be accessible to motor vehicles, but they were intending that area to be accessible to motor vehicles. So I think if it's specifically designed or meant to be used for vehicular traffic, then it falls within the statute. Even if it's temporarily being used for vehicular traffic, then it would fall within the statute.
I would like to direct your attention to a different definition of generally that the Court of Appeals looked to, which talks about to or by most people, or widely, or popularly, or extensively, which seems, if you put that before the word accessible, seems to speak to the expected volume of activity on the private property at issue. And you referenced the Nickerson case. That case involved the pit area of a speedway, and the Court of Appeals said that the pit area is a place where vehicles are routinely permitted to enter for the purpose of driving and parking, which again, in my mind, speaks to some expected volume of activity. So my question to you is, if the legislature extended the coverage of the statute in 1992 to cover private or at least non-public properties, is it your position that it covers all non-public properties and therefore covers everything, or that it covers some and not others? And if so, my operating theory is maybe we should draw the line based on this expected volume of activity. And I guess the question is, why would you reject that?
I disagree with this expected volume of activity.
Why?
Because that is, you're looking at the open to the public. If you're looking at the language open to the public, that is expected activity.
Before you get there, it's certainly possible to have private property not open to the public, but that would have a higher volume of activity. And again, in Nickerson, talked about the purpose of the statute. This construction's in accord with the purpose, which is to prevent the collision of a vehicle being operated by a person under the influence with other persons or property. So it seems reasonable to me to think that the legislature might have been thinking of extending the statute onto private or non-public property, but only when there's going to be some amount of activity where that type of protection would need to occur. Why am I wrong?
Because you have to look at the plain language of the statute. It says generally accessible to motor vehicles. It does not say generally accessible to the public. Generally accessible to motor vehicles means it could be defendant's own motor vehicle. It does not matter whether it was defendant, an invited guest, or even an alleged trespasser who was on defendant's property, because what we're looking at, the meaning of the phrase generally accessible to motor vehicles is not dependent on the category of the driver. And that's where I think the Court of Appeals erred in this case, because they were trying to apply Fourth Amendment type issues when they're looking at the curtilage and the fact that this was defendant's own property. That is a separate issue. Defendant can always raise Fourth Amendment issues, but that is not the issue for us. Pure statutory analysis, looking at the plain language of the statute, which says generally accessible to motor vehicles. How can a driveway not be generally accessible to motor vehicles, even if it's defendant's own private driveway or own vehicle?
Thank you, Ms. Mayor.
You know, I'm sorry, I just want to gather one other key thing, and I promise I'll stop asking questions, but I'm really trying to, when we talk about general accessible, I just want to give you another quick hypothetical that I'm trying to think of. Because does it matter the type of vehicle that you're operating? You know, does it have to be a road? Does it have to be, what if I have a large patch of land and I'm in agriculture, I do farming, and that's my business, that's my life, I'm in agriculture. I guess my question would be is that, let's say I'm operating my farm equipment, and I'm not drunk, but I'm just, I have a beer, and I'm having a beer as I'm driving, my equipment on my property, right? So I'm doing the work that I'm doing, I'm not intoxicated, but I do have an open container, it's on my farm equipment, it's, it's a hot day, and I just want to have a beer. Is that generally accessible?
Well, for one, the issue is whether he was operating while intoxicated. Having one beer is not necessarily operating while intoxicated.
Okay, let's just say hypothetically, let's just change hypothetical. Let's just say I'm operating my farm equipment, I'm doing my work, and I'm having a beer or two, and fine, I'm over the legal limit, but I'm on my property, I'm on my farm, I'm doing my work. Is that generally accessible to law enforcement to then come on?
Well, any area in the United States is generally accessible to law enforcement. The question is it a Fourth Amendment violation?
I'm sorry?
It comes down to whether there's a Fourth Amendment violation. But the government can intrude on any piece of property in the state of Michigan under the police powers of...
No, I understand, but under our analogy, though, is that generally accessible under the conversation that we're having here?
For one thing, I'm not sure about farm equipment, if that would fall under the definition of a motor vehicle.
Okay, then let's just change. I'm just trying to gather if I'm working on a farm, on a large area, and I'm operating whatever piece of equipment it is, and for the hypothetical situation, I am mildly intoxicated. But I'm on my property, I'm on my farm, I'm far away from absolutely everything, and I'm just doing my work. Is that generally accessible under the statute that we're talking about today?
I guess you would have to determine whether it is a vehicle would be the first thing.
Okay, let's just say it's a vehicle. What type of vehicle isn't really important. I'm trying to understand.
Well, it is when you're talking about farm equipment in middle fields and it's only a farm. If you're talking about something like a pickup truck back in that area, even if we couldn't charge, because I'm not saying we can't, he can be charged with exact same criminal penalties under the Natural Resources and Environmental Protection Act. The exact same penalties, a misdemeanor and a felony for a third offense. So why shouldn't we be able to charge for someone who's driving on their driveway a criminal offense when someone's on their back 40 can be charged with the exact same criminal offense? I think, your scenario is somewhat problematic because of the whole farm field, but there may, in particular instances,
my question is, I'm just trying to understand this question. Is a farm generally accessible under a scenario that I've given you? If there's no road that's getting to it, there's no road, but is it generally accessible?
I don't want to make this so broad that people will cringe when they read this case. My argument, my rule would be, if it's usually or normally used or designed for vehicular traffic, then it would clearly fall into the statute.
Okay, thank you. Thank you, Counsel. Ms. Barkovic?
Thank you. May it please the court, Camilla Barkovic appearing on behalf of defendant appellee, Mr. Gino Ray. We're here today to determine whether or not the area upon which Mr. Ray operated his motor vehicle on the date in question falls within the Michigan drunk driving statute. Obviously, this court's aware that there are 3 specific areas enumerated within the statute: highway, area open to the public, or a place generally accessible to motor vehicles. Obviously, the 3rd category is at issue in this case. The court is in a position to interpret the law as written. The legislature is responsible for drafting the law, and the court's main goal in interpreting any sort of legislation is to effectuate legislative intent. And in this case, I believe that the legislative intent is clear from the plain language or structure of the statutory provision. First and foremost, obviously, as I previously indicated, the statute specifically enumerates 3 categories. What that implies is that there are certain places the legislature did not intend to preclude drunk driving, and furthermore, that the legislature did not intend to criminalize drunk driving in all areas within the state. As I cite in my brief that I submitted to this court, the legislature could have simply indicated all areas within this state. They did not do that, and they've clearly done that in other statutes. We've referenced some earlier this morning, but also the commercial motor vehicle drunk driving statute precludes operating a commercial motor vehicle while intoxicated in all areas within the state. And what I find most interesting about that is the same exact legislature is the legislature that enacted the amendment to the OWI statute in 1992 and enacted or amended the drunk driving commercial motor vehicle statute to say all areas, so they clearly knew it. In addition, there are, yes.
What areas are currently covered under the statute that, in your judgment, were not covered under the pre-1992 statute? In other words, could you give an example of an area that is generally accessible to a motor vehicle, which is part of the new statute, but is not also open to the general public, which was the focus of the old statute?
Yes, absolutely. Obviously, the old statute only precluded drunk driving on highways and then areas open to the general public. There are areas that are open or that are not open to the general public with which the new amendment obviously encompasses. One of those would be, let's say, a private road. There was a case in the state of Michigan previously, City of Holland versus Dreyer, if I'm recalling correctly. It was a private road throughout a mobile home park. Basically, generally only residents used the road, but it did cut off a main thoroughfare, so that would be one. Another one would be like a gated community. Obviously, that is not open to the public.
So a private road would be subject to coverage under the new statute, right?
Yes.
Even though it is arguably the case that would be less accessible to most members of the public than would a driveway.
Absolutely, but I think the problem that I guess maybe courts were running into is people would maybe argue that simply because the general public wasn't able to access an area, that they shouldn't be liable under the statute. And the thing is, there are areas where a large number of people, members of the public, or even, I guess, a private group of individuals may be put at risk by this type of behavior. And I think that's what the amendment covered, are those specific areas. So let's say like a gated community. Well, there may be, let's, I guess, assume 20 homes in that community, so there's a limited number of individuals that reside there. There's a limited number of people that have access to that area. But still, the roadway is generally accessible to motor vehicles because obviously it's more often than not used for that purpose and by a large group of people. And I guess you need to interpret the statute in a way that effectuates the intent of the legislature and the public policy behind the statute. The public policy isn't simply to protect one person from his or her own conduct or a very, very limited number of people from their own conduct. It's the public at large. And that's why I think the legislature chose these three categories, because they ensure that the general public, the public at large, and public safety is protected.
So is that, the test you seem to have articulated is more often than not used by motor vehicles and used by a sufficient number of people. So the private road that in your gated community with 20 houses would meet both of those definitions, a sufficient number of people. But what if I have a private community and there are only 2 houses in my little gate? Just me and Justice Viviano, because we're the only 2 people who can get along or something like that. So we build a little gated community and there's just the two families. Does that count?
Well, first of all, it sounds like a great community.
Thanks.
However,
Is that because of her or me?
both, absolutely. I think that in that case, what you have to look at is the nature of the roadway. So there is a road, people are expected to be traveling on the road, and when you're on that road, you can expect to encounter other motor vehicles, whether or not 2 people reside there. In that circumstance, just because the roadway is private and only a few, I guess, people might have access to it, it's still of the nature that you can expect to, let's say, run into a drunk driver or something like that. The upper portion of the driveway in this case, which was encompassed within the backyard and side yard of the residence, is different. The nature of the property is different, and I think that's what you need to look at.
So it's your I didn't understand, the Court of Appeals did rest its decision on the distinction between the upper part of the driveway and the lower part of the driveway.
Right.
But I didn't understand that to be your position. Is that your position? Does it make a difference whether it's the upper part of the driveway or the lower part of the driveway, or is it the whole driveway?
I think, to be honest with you, I think it's a factually specific inquiry, and I think in this case, the area in question it does not fall within the statute, but sure, perhaps areas closer down to the sidewalk, closer down to the roadway, where other people can be expected to be present is what's at issue.
So, I'm sorry, I just need to figure out what definition of generally we're supposed to apply. I mean, if generally means typically, then it's quite typical for your client to drive in and out of his driveway, I assume. On the other hand, if it means a definition that has something to do with who has access to it, the definition Justice Viviano asked opposing counsel about, or one of the common definitions is without distinction of one from others. And I think of a driveway as having a distinct, your driveway is for you and your invited guests, so it isn't necessarily for everybody. How do we pick which definition we use? Because I think with one you might win and one you might lose.
Absolutely. Well, I think that clearly indicates that the statutory phrase at issue is ambiguous, and so my contention would be that it should be construed in favor of the defendant. Obviously, in my brief, I cite the rule of lenity. Clearly, it's my contention that this statute defines a criminal offense for the reasons I did set forth in my brief, and therefore, it should be construed to exclude the conduct at issue. But jumping back, I mean, it is a difficult decision to make, but once again, I think it's the nature of the property, and if you look at the underlying purpose of the statute, which is to protect society as a whole, rather than you from doing what you want on your own property.
If that's the purpose, you may, oh, I'm sorry, you guys go.
You keep drawing to this property or other people can be expected in public safety, but why is that? I mean, I've been around a while and I've encountered a lot of drunk driving cases where it's a single vehicle accident that runs into a tree or a building or a home. Why does it have, what in the language requires this? If it's public safety, isn't it also the safety of the operator of the vehicle? So I don't see where you're getting this notion that if it's an area where other people are around, okay, that there's, you're under the statute, but if not, then you're free to harm yourself?
Well, I guess the issue then becomes, I guess, looking at the nature of the roadway. Like, if you're on a highway, obviously there are higher speeds that cars are able to reach. If you're on another roadway, obviously the car would generally be mobile. In this circumstance and in the upper portion of a driveway, you're not traveling at speeds or in any manner that you could really cause a substantial risk. And if anything, it is your own property that's truthfully at risk, and you are entitled, I mean, people have an interest.
What about people on your own property, though? What about, what about, exactly, like, what about if you have children? What about what about the idea that it's not just the actual individual, as Justice Zara was talking to, but let's expand it. What about other residents of the family? What about of a child or a spouse or an animal?
Or a police officer executing a search warrant within the habits of the country.
Absolutely. Well, I mean, the bottom line is, if the legislature did intend to ensure the public of every single person that absolutely may be at risk from this sort of conduct, they would have said anywhere within the state. And other legislatures have done that. Ours specifically didn't. They knew they could, and I think it says a lot. Because obviously, this court can't sit in the position to decide what the best policy is. That's the legislature's job. They set forth what they intended in the express language of the statute, and I'm just asking the court, based on what I've articulated earlier, to construe this in a manner to effectuate that intent. Because if this court were to construe the statute to include the conduct or area at issue, then there's no place within this state that the statute wouldn't apply. So effectively, this court would be rewriting legislation, which obviously, with all due respect to the court, that's not the court's job.
So, counsel, in what place of the state should it apply? I mean, I guess my question would be, I like to ask it in the other context. So ultimately, where should it apply then? What would the extension be to you? As I asked, your sister counsel, when I asked her the question, which is, tell me an area that isn't generally accessible. Give me an example of a place that is not generally accessible. Other than this situation, this specific driveway in this specific circumstance, where do I draw a line to say, okay, you know what? This is not generally accessible.
I think what you proposed earlier, driving on secluded farmland, you own a lot of property, clearly anything can be accessible. And this jumps to some of the questions you had asked Sister Council, is the inclusion of the term generally. Obviously, it was intentional. My contention is that it limits the scope and applicability of the statute because technically anywhere is accessible. If you look at accessible, it means ability to enter. If I want to drive my car through a physical barrier and place myself, let's say, in someone's backyard, I guess it's accessible. Or if I want to plow through your farmlands to get to the area where you are, I have access to that, technically speaking. However, the statute and the language utilized in the current statute clearly indicates that that's not what the legislature intended.
Counsel, just as my colleagues have inquired about the meaning of the word generally, I'd like to inquire just a little bit more about the meaning of the word accessible. Accessible has several different understandings. One is that it's permissible to do something. Another is that something accessible has drivability. It can be entered. It can be driven on. To the extent that accessible focuses on permission, it seems to me it's increasingly tantamount to the other clause in this statute, that is whether or not there is something that is open to the general public. To the extent that that's true, accessibility must connotate some sense of drivability. Is it something that can be driven on? In which case there'd be absolutely no basis for a distinction between the upper and lower part of the driveway. What does accessible mean to you precisely?
Well, if it's something, and I will address your question, but if it's something about how you have simply indicated that it's able to be driven upon, then once again, the legislature could have just said any area within this state, because technically any area within this state is able to be driven upon.
A badly maintained road might not be easy to be driven on, for example.
Right, but it is still able to be driven on, and
What does accessibility mean to you precisely?
I don't believe that it means physical ability to enter. I think that it should be confined and may be confined to the issue of implied permission or...
And you think that that largely tracks and duplicates and is redundant of the other clause in the statute?
No, I don't. And if we're looking at redundancy, I mean, a highway, technically, by definition, under the Motor Vehicle Act, is open to the public. Then you have, subsequent to that, open to the public as a separate category. Then now we get to generally accessible, and I think it covers areas that aren't open to the public. And so obviously that would be areas where people don't have permission to go into. And generally speaking, there are several areas, like I articulated earlier, perhaps like a private roadway, or how in Nickerson it was a private speedway. They obviously had to pay an admission fee to get in to that area, so the general public wasn't allowed, but at the same time, people, a large portion of the community would be at risk by conduct.
So, Counsel, I have a question, though, because we're trying to look at this not just as it pertains to your client, but just for how these cases are going to be enforced across the state. And I guess my question would be is, in the scenario that we have here, how should law enforcement have done this differently?
How should law enforcement
What should the
have
police
done?
officer have done differently in this case?
I don't think that he should have entered Mr. Ray's property. The area in question was extremely private in nature, was intimate to the home.
But the question is, so then, if the police officer is concerned about the fact that, wow, this person could go onto the road and really hurt some folks, what would you have liked the officer to have done? Should he have just left?
But I don't think the officer had that thought, because there was no indication that Mr. Ray ever intended to leave his property. There were 3 instances in this case, and all of them involved him playing music. So I guess if we get into that, clearly officers, and I will acknowledge that officers, if they observe the commission of some sorts of crimes, may enter to investigate. However, in this case, it would have been limited to the music, the noise violation.
So if the police officer sees him in the car and, sees him with the engine on and sees that the car has moved, and the police officer is not allowed to take your argument would be that the police officer can't take any steps at that point to protect the public?
Well, he would be speculating. I mean, that's just assuming that Mr. Ray would have left his residence. And it's my contention, obviously, that that doesn't fall within the drunk driving statute, so the police officer wouldn't have an ability to essentially arrest him for that conduct. What the police officer should have done is came up to him and issued him a citation for perhaps disorderly conduct. A noise violation maybe under a city ordinance, but there's no indication that he ever intended to leave the residence, and that's evidenced by his prior conduct on the night in question.
Could a police officer make an arrest if the individual is driving drunk and they get to their private property, they get onto their driveway, it's not, and we agree that it's not accessible, or we're like just taking this as a hypothetical, would a police officer be able to make arrests for drinking and driving if the actual kind of determination was made on private property? Under your definition, the property is not generally accessible. Could the police officer then effectuate an arrest if that person drove onto the property?
Well, no, I disagree with you, because the only time the area is relevant is to the area of operation.
Right.
So if he's, obviously in that hypothetical, the police officer would have had to observe him traveling on a highway.
Let's say he did. The question is, when he makes the actual stop and he effectuates the sobriety, is he allowed to do that under your definition? If it's not generally accessible? Or does he have to do it before he gets to that location? So if he gets to that location, is he then free?
No, because he had operated the vehicle on areas prior to that location that fall within the statute. So I understand what you're getting at, basically sliding into home base, you're clear, free. That's not applicable to this situation, because in this situation, obviously, Mr. Ray was never operating anywhere but the upper portion of, I guess you would say, his driveway, which is encompassed within his backyard and side yard of his residence. And so when you look, the operation has to occur in one of the statutorily enumerated areas, not the arrest.
Ms. Barkovic, your time is up.
Thank you.
Ms. Day, your time has also expired, so this case will be submitted. And once again, thank you to all of the audience for being here, for the hospitality that you've shown us. So we'll look forward to seeing you at the reception later. Thank you.
In just a couple of minutes, we'll do a short question and answer session. If there's any of our public officials that prefer to excuse themselves instead of participate, that's just fine. We'll give these two a minute to catch their breath and maybe have a sip of water, and I'll turn the podium around and we'll get started. I would note that when we do get started, while I do have some questions for the litigants, I'd encourage especially the students to ask any questions that they have. There's a microphone down front here on the right, on my right and one on the left. So please, if you have questions or things struck you there, please come down. Don't hesitate to ask them, and we'll answer the questions the best that we can. So just a couple of minutes and we'll get started. can take this off, whatever you want. Again, good afternoon, everybody. Everybody hear me okay? Or good morning, I guess I should say. So again, our litigants for the people of the state of Michigan, Ms. Marilyn Day, and for the defendant, Camilla Barkovic, please congratulations again. My name is Tom Clement. I'm general counsel for the Michigan Supreme Court, and welcome all. I want to thank everybody, Petoskey High School especially, but all of the surrounding areas. Welcome to the students, but thank you for welcoming us here to conduct a session of court before you. This is obviously very important work, and I can tell you each of the justices takes this incredibly seriously and is thrilled to be able to take this around to various places in the state of Michigan. We were down at River Rouge about 6 months ago, and we try to do this twice a year or so. It's a great opportunity not only for the students and the local officials to see how the court actually operates, but for the court as well to get around and to meet people and to see how their decisions truly do impact more than just those of us who work in the Lansing area. So I'd like to get down right to brass tacks with the litigants here and ask them what their general impressions were of the argument now that we're through it here. Dan, you want to start?
Well, you know, I knew coming in that this would be somewhat of a hard sell, but I think if the court focuses on the fact that it was a driveway, then potentially we could have a successful opinion. But the reach of the statute is very, very broad. But that is an issue for the legislature to address, not this court. This court is required to look at the plain language of the statute. I don't know if you guys in your classes read our briefs, but I cited to a case out of Vermont where the Supreme Court of Vermont had indicated that a private driveway was basically accessible and open to the public. Well, what happened after that case came out is the Vermont legislature amended the statute and specifically precluded private residential driveways from their statute, the OWI statute. So the legislature can change the statute at any time, but the Michigan Supreme Court can't change the statute. They just have to interpret the case according to the plain language of the statute.
Ms. Barkovic, do you have any impressions?
And just following off what Ms. Day said, obviously I have a different interpretation as to what I hope the court does in this case. Obviously, as I articulated earlier, there are three specific areas the legislature specifically indicated that one can't operate a vehicle while intoxicated. Nowhere in that statute does it reference, obviously, the area in question in this case. And I think it says a lot about what the legislature intended by the fact that they didn't just simply say that one cannot operate a vehicle while intoxicated in all areas within the state. As you heard during our arguments, clearly there are statutes within which the legislature did do that. But I think the legislature had in mind when it enacted this statute that there were certain areas where this should not be made a crime. And I think that the area in question, 50 feet from the roadway, at the end of someone's driveway, right next to their detached garage and their side entrance to their house, essentially behind a fence line, I think that's one such private area that the legislature didn't contemplate criminalizing such behavior.
Thank you. And again, we're more interested in your questions than we are mine. So if you have any, please feel free to make your way down. Obviously, we spent a long time talking, or the entire time talking about that phrase, general accessibility. Ms. Day, I was struck by your argument that when you were talking after your first 2 minutes had expired, Justice Bernstein came right out of the gate, which caught me a little bit by surprise. And one of the first things he talked about was governmental overreach and started talking to you about that. And then we went on this kind of hypothetical journey where we talked about down by a lake, and you were challenged to answer questions about that and general accessibility. Justice Bernstein took you to a farm, a big farm, and tractors and this and that, and you were challenged on that. And I think a couple of other justices had you in different places through hypotheticals, and that took you through about 10 minutes of your argument, and they seemed to hit you on specifics over and over and over again, where they would try to get you into a corner and then have you sort of back your way out of it. But then you came up with, or you put out there, general accessibility is meant or designed for vehicular traffic. And it seemed like that sort of stopped them in their tracks. Can you talk about that general test that you were speaking of there, and perhaps why that didn't come out a little bit sooner in your argument?
Well, it would have came out if I had finished my presentation before I got answered the question. But the issue in this case is a driveway, and the driveway is so clear that the statute applies because the legislature has defined what a private driveway is, and a private driveway is defined as used for vehicular traffic. So if the legislature has already defined a piece of property as used for vehicular traffic, it by necessity has to be generally accessible to motor vehicles. And to not go down the rabbit hole of the farm field and everything else. This case was a MOA. They haven't even granted a full leave grant on this case. So I was trying to keep the justices focused on driveways, and not just defendants' driveways, but any driveway. A driveway, the word itself means drive. You're driving on a driveway. So a private driveway, by necessity, is generally accessible to motor vehicles. And if I could get an opinion from the Court of Appeals or by the Supreme Court to say that, I would be very, very happy. There are many, many other scenarios that, potentially there could be fact questions on let's say there's a car in the back 40 in the middle of the field. Okay, is that generally accessible? It might depend on some facts. That might be a fact question. But a private residential driveway, that's as a matter of law, generally accessible to motor vehicles. And if the court is disturbed about this, I don't think it would be, because you have to look at the plain language of the statute. And I don't know, ask any other questions you have, but the private driveway is obviously to me generally accessible to motor vehicles. And it's based on the definition already set forth in the motor vehicle code.
Thank you. And then, Ms. Barkovic, the first place, so when we're talking about this manner designed for vehicular traffic, so my question would be, one, I presume that was addressed in Ms. Day's brief. Did you respond to that in any way? And what is your response to that? But more importantly, one of the first places you went in your argument was to legislative intent, and then Justice McCormick and you had an exchange where she basically says there's potentially two interpretations of this generally accessible term. One you win and one you lose. She said that specifically, and you brought out the rule of lenity. And you said, well, there's 8 smart people up here, all lawyers, that are talking about this, and essentially what you were saying is, how am my client supposed to know what the term of general accessibility is if the rest of us can't figure it out? So is that generally the path you were going down, or do you care to expand on that at all?
Well, obviously, my contention is I think it's a little bit more than just simply a private driveway in this case. Sure, Mr. Ray may technically have been on a paved driveway. However, the portion of the paved driveway that he was on was encompassed essentially within his backyard. And so I think that, sure, maybe there are certain arguments that can be made to private driveways as a whole, but you have to look at the specific nature of the area in question. And when you look at that and you look at the facts and circumstances of this case, I think that the conclusion is clear, and that's simply that a large number of motor vehicles generally don't access the area, and I think that's what obviously the legislature was looking at when they enacted the statute, just given the nature of the categories that they set forth in the statute. With respect to the exchange with Justice McCormick, obviously the rule of lenity indicates that basically criminal offenses must be clearly set forth so individuals know what conduct is permissible and what conduct is not permissible. And clearly, just evident in the fact that we're here and that we are arguing. Everyone probably on the stage may have a different interpretation of the statutory language, and under those circumstances, what the law says is that the statute should be construed in favor of the defendant. And so, as a backup argument, I set that forth.
Thank you. It looks like we have an audience question. You tell us your name and ask your question, please.
Hi, I'm Olivia Vargo. I'm from Boyne City High School. We debated this in class. We went through all the briefs and talked about all of that. What I'm wondering is why neither of you delved into the details of the case, because we know, I think that you mentioned when they asked you what is not generally accessible, then you mentioned like a gated driveway. What makes this case different is that the police officer was parked at the end of the driveway, barricading him from leaving. So even if he had intent to drive on the road, it was not possible for him to. So what do you say to that, and what makes this?
I think that's where you can use one definition of generally accessible. And it's not crystal clear because this has not been a full trial. This was just one evidence you're hearing, and this was a motion to quash. And basically with a motion to quash, you're only looking at the evidence from the preliminary exam. The hearing that happened in the circuit court, really you shouldn't even look at that for a motion to quash, because the circuit court judge is looking what the district court judge did and finding whether defendant's conduct fell within the statute, okay? In this particular case, the officer, it's not 100% clear if the defendant could not have backed out. But what is clear is the officer was walking up his driveway because of a third noise complaint. This isn't they were investigating a drunk driving case. There's no evidence that they were investigating drunk driving. They were there as a community caretaker function. There's no Fourth Amendment violations here. It was a community caretaker exception. They can go up on their driveway to talk to the defendant about what happened. When the officer was walking up to the door, that's when defendant starts backing out of his driveway, and that's when the police officer had to shine his flashlight so the defendant didn't actually back into him or the car. Okay, we don't know how far defendant would have moved down, and that's why our argument that this whole area is generally accessible to motor vehicles. Police officers making these split-second factual scenarios. If he had moved down an extra 10 feet, that would have been generally accessible, but because where he was, that was not generally accessible. And it mattered that he was backing down the driveway and instead of going forward. These are fact questions that should not be resolved when you're looking at an element of the offense. The element of the offense is a question of law that the court has to decide, and that's a matter of law, and it's not a particular fact question in this particular case. It's just a matter of law. And, and I know people have problems with us charging this type of cases, but it's up to prosecutor charging discretion, okay? I have been in the prosecutor's office for 23 years. I have gotten phone calls from the warrants department asking, there was somebody in the back field, he was all alone, should be charged, and we go back and forth whether to charge or not. It all depends on the situation, whether we as a prosecutor are going to charge. We believe that a driveway, as a matter of law, is generally accessible to motor vehicles, and he was driving on the driveway, and he's a habitual repeat offender. So we want to get him off the streets. He had 7 prior drunk driving convictions. He was been in prison 3 times and in jail 1 time for prior drunk driving. So we used our prosecutor charging discretion and decided to charge him because we felt that his conduct driving on a driveway is an area within the location set forth in the statute.
But then, with that mentioned, you decide what cases you're going to take. In what Judge Bernstein talked about, he talked about your definition of generally accessible was then almost every place in the state of Michigan would be a place that is generally accessible to motor vehicles. And if accessible is a place that you can drive almost anywhere. So going along with that, wouldn't you then have to take all of these cases?
It's a purely charging discretion. And the DNR code, we get those cases too. You're on your snowmobile, you're on your ATV, you're anywhere in the back 40 and you're drinking and driving, we can charge you, okay? Then the question is, why are we back in the back 40? That's a Fourth Amendment issue. That is whether the police have the authority to be where they are, okay? Technically, we can charge pretty much anywhere in the state if you're drinking and driving. And the reason is that is because the legislature recognizes how dangerous it is to be in a vehicle while intoxicated. And I'm not talking about one drink. I'm talking about the law that says intoxicated. You're impaired, you're under the influence, you have a .08. The Michigan Supreme Court has recognized that that is grossly negligent as a matter of law. You're grossly negligent if you're behind the wheel of the car. And in Michigan, when you look at the word operate, it means actual physical control. So you don't even have to be driving a vehicle. It's a prophylactic measure to get these people out of the vehicles because it's such a dangerous activity to be behind a wheel of a car while you're driving. It's not just a physical act of driving, but the potential that they could be moving out into the public or wherever he may be. And in this particular case, is it any less relevant that he's in his driveway? Say of his neighbor who was complaining about the noise complaints. Say if his neighbor was in the driveway and got hit. Can we not charge the defendant for causing a serious injury while intoxicated because it was his neighbor in his driveway? You should be able to charge in these particular cases. And it has to do with the vehicle. It's different from open to the public. That is when people don't expect cars to be in the lawn of the dormitory at Wayne State University. You wouldn't expect the car. So they have that open to the public. In a driveway, people expect cars to be in their driveway. So that's all, what's the expectation? And it's like I said, it doesn't lessen the culpability if he is in his driveway and hits his neighbor, or if he actually got out and was on the street and hits his neighbor.
And then,
It's a lot to respond to, but I can try. Obviously, it's my contention it's completely irrelevant whether this is the defendant's first operating while intoxicated charge or his seventh. Clearly, what's at issue is the law, and the law is something that affects everyone in this room, because obviously we would all like to know what is criminal conduct and what's not, especially in an area where some of us, may have been cleaning out our cars while having an alcoholic beverage, put the car in gear, and reversed maybe a foot. If the court were to rule or agree with the prosecutor, under these circumstances, even if we never even intended to go in the street and are simply enjoying ourselves on a Saturday afternoon, we're essentially subjecting ourselves to criminal prosecution, and I don't think that that is what the legislature intended to do with this statute at all. And once again, if they did, they would have said so. Another thing is, the student aptly noted that we didn't argue the facts of the case, and just for the students, obviously the justices are provided in advance with all of our written briefs and things of that nature, which include a summary of all of the facts relating to the case. I think it's an excellent observation that she made that the police officer's vehicle was blocking the entryway and or exitway of the driveway, and so it wasn't accessible really by any means at that point in time, and that is something we did set forth in our brief.
Thank you. So we're running short on time. We have time for a few more questions, so I want to go over here. But I would just indicate if your questions we aren't able to get to it in this public forum, please stay back, and I think we'll have a few minutes that we can continue to answer questions that you may have. So,
Jonathan Shield, you've touched on quite a bit what I was going to comment on, but in rural Emmett County here, when you're talking about just driveway, we have quarter-mile-long driveways. We have also farmers who are on their back 40 driving licensed vehicles, hauling grain or working on, as you stated, working on, and so I see that possible on a Saturday afternoon or on a Friday or any other day, that there possibly could be alcoholic beverages and the possibility of being in that vehicle and moving it, but not necessarily a danger of harming other public. So I'm worried about that overreach. I want the public safe. I want to protect the neighbors. I want to protect children. I want to protect all of that. But I'm worried about the overreach of just calling because it's a driveway. Yep, that we can charge people, and that makes it an automatically offense. Thank you.
I think what you have to consider is the fact that you had a drink and are operating a vehicle. It's not what's criminally liable. It's when you're operating while intoxicated. And there's a specific, we all know what that means. It's a .08 or impaired. It's not just having 1 or 2 drinks. Let's assume you're totally, you're a .3 and you're in your back 40 or on the farm equipment or wherever. Yeah, I think we should, as a state, be able to charge you because you're dangerous, if not to the public, you're dangerous to yourself. And Michigan has never used a rule of lenity for the vehicle code. They don't use it for the public health code. They do use it for criminal statutes, but there's many states that said the rule of lenity simply does not apply for OWI offenses because it's so clear and obvious and dangerous that in fact it's a remedial statute and you have to strictly construe it against the defendant. So when you're looking at an action that's grossly negligent as a matter of law, I don't think it's too far-fetched to say if you're on a driveway which is normally used for vehicular traffic, then you can be charged with an OWI offense. Whether you are or not, I can't imagine you would be charged with an OWI offense in that particular case unless for some reason the police was called out to your property or if you hurt someone. If you hurt someone in your backyard while driving while intoxicated and you're on a driveway, you should be charged. And it's not state overreaching, it's a matter of public safety, either for yourself or whoever might be around.
Yeah, let's try to. If we can go over here and do.
Mark Antoni, Broad City. Just a quick question of procedure. I was really impressed with how quickly you were able to answer the judge's questions, and when they interrupted you, but neither of you got to your prepared comments. I think you had asked for 2 minutes reserved, but I don't know that you ever got it for your responses. Do you guys practice this in terms of having people interrupt you, fire questions at you? Because it was amazing how quick you were able to respond to the questions. Thanks.
Sure. Obviously, you can't anticipate what you're going to be asked 100%, but you can speculate. Obviously, the prosecutor has made arguments in the briefs that she's submitted to the court, and I've made them as well. And based on those arguments, I think you can see what the other side's position may be, and obviously you anticipate that you'll be asked to state why your position is correct and why the other one that's advanced should not be adopted. So it's definitely something that you can prepare for to the extent possible, but once again, I think that there are some wild cards that can be thrown.
Thank you.
Fortunately, our office is pretty large. We have over 100 attorneys in the Oakland County Prosecutor's Office, and I think we have 8 appellate attorneys. So every time one of us have argument before the Supreme Court, we always do a mock argument. So I got to practice this in front of 7 or 8 other attorneys, so they were asking questions back and forth, and that was very helpful.
Last question, because the justices are waiting, but for those of you who remain, if you want to come up and ask the questions, please feel free to do so. You name the question.
My name is Forrest Walker from Petoskey High School, and my question is, if the ATV and snowmobiling laws are so much more clear about the drunk driving, then why would they make the more popular the car drunk driving statutes so less unclear? Because if it's like the private property or the generally accessible, what do you think that they really intended?
That's a very good question, because I would love it if the drunk driving statute said anywhere in the state. But the DNR statute, it's a different purpose because they're regulating, like the snowmobile, they're regulating the snowmobile usage. There's no Secretary of State implications, so they can keep it anywhere within the state. And even for ATVs, there are some licensing sanctions, but it's not the same as regular, motor vehicle sections. It's interesting because when the OWI statute was amended to include the generally accessible to motor vehicles, the ATV statute and snowmobile statute weren't as strict. Okay, the BAC contest was 0.1 as opposed to 0.08, and the criminal penalties weren't as high. So after in 1992, when the OWI statute was amended to include the language generally accessible to motor vehicle, subsequent to that, then the ATV statute and those statutes were actually brought in line pretty much criminally wise with the OWI statute, but still they had always used the language basically anywhere within the state. But it's different because you're looking, the motor vehicle code is a little bit different. They're trying to prohibit the use of the vehicles, but recognizing that vehicles are used in private places such as driveways and private roads. And one thing Defense Counsel had said, I just wanted to mention that I didn't get to mention before, private roads are specifically identified in the motor vehicle code as being open to the public. So when they amended the statute in 1992, that was already included. So they didn't reach in and grab those areas because they were already included before the statute was amended. So the statute had to have been amended for a particular reason. And I think the particular reason was to include those areas that are usually used for vehicular traffic.
Thank you.
All right, just a couple of finishing comments here, especially for the students that are here. I want to commend our litigants. I just want to impress upon each of you, I can't impress enough how much work goes into preparing for one of these arguments. You saw each of them up for 15 minutes in a very high-stress situation, high-pressure situation, answering a lot of very, very difficult questions. But I can promise you that for each of these women, hours and hours and hours of work went into preparing their briefs, preparing their arguments, and doing the argument that you just saw, not only in this court, the highest court in the state, but in 2 other courts as well, or at least 2 other courts as well. So I want to commend each of them. I thought they both did a fabulous job, and thank you again for coming up here and doing this and taking time out of your schedule. Justices are waiting for the reception, which I'm not exactly sure where that is, but...
We'd like to invite you all to a reception that's been prepared by our commercial food students. It's most easily accessible by exiting this side of the auditorium. It'll be housed in the commercial foods room and behind stage, which you can again access from this hallway. Thank you.